Sale and purchase agreements are long and complex documents. Watch this video to learn about the main things you need to know to avoid costly mistakes. So first, what is a sale and purchase agreement, also known as an SPA? Simply put, an SPA is a contract that details the sale of a business from a seller to a buyer. The SPA comes in two main forms, as a share purchase agreement and as an asset purchase agreement. I made a video that details the differences between share purchases and asset purchases. It's linked in the description below. So what to include in a SPA? First, we'll need to understand who is the real seller. Is it the person that is holding shares of the company, or is it the company itself that is selling you its assets? Second, as a buyer, you'll want to include extensive warranties that protect your interests. Warranties are like promises that are made by the seller to the buyer in regards to the state of the business. As a solicitor, I would advise that every time the seller makes a representation to you in regards to the state of the business, you include that in the SPA as a warranty. This will help show that you relied on the statements made by the seller when deciding whether to buy the business or not. The third main thing that you want to include in an SPA is the post-completion obligations of the seller. Just because you bought the business, it doesn't mean that you are immediately able to run it as if you've had it for years. You'll need the seller to cooperate with you and grant you access to, for example, important accounts. I'm Malcolm Zoppi, a qualified solicitor and the managing director of GZ Legal. GZ Legal is a boutique corporate and commercial law firm that specializes in drafting commercial contracts and helping clients with their corporate law needs. Right, so what are some of the things that you should be aware of in an SPA? Look out for the word disclosed. If anything is deemed disclosed to the buyer, it means that the buyer is deemed to have known about any of these specific issues. That means that you as the buyer will find it very hard to seek recourse against the seller for the issues that have been apparently disclosed to you. Second, look out for any indemnities. Sometimes sellers will include indemnities that protect themselves after the business has been sold. Indemnities are contractual obligations, for example in this case of the buyer, to cover any costs or damages that might have to be paid by the seller. Now, the SPA is part of a larger process in the acquisition. Before the acquisition is completed, exchange and completion, make sure to request from the seller a disclosure letter. Third, if you're doing a share sale, make sure to comply with the Companies Act. This will entail drafting board minutes, general resolutions, and registering the transfer both at Companies House and in the internal registers. This is a critical aspect that is often overlooked, but determines whether a share sale is valid or not. Thanks for watching. Check out the rest of the channel that covers a range of legal issues that are relevant for small businesses in the UK. Also, if you're looking for a free legal advice call, visit our website now. It's linked in the description below.